I will start by offering the floor to Sjoerd, who is a professor in the Netherlands, Zijlstra, who has done enormous work on a comparative level on legislative drafting. And I think it would be great if he could start with a sense of where we are with legislative quality right now. Sjoerd.
Thank you, Helen. To introduce myself, I'm Sjoerd Zijlstra, Professor of Constitutional Administrative Law at the VU University of Amsterdam and Professor of Legislation at the Curacao University. I want to say a few words about the way the quality of legislation is safeguarded in the Netherlands. And maybe after that we can make some comparative remarks. I can only make a few sweeping statements, leaving nuance aside, which is not the way scholars normally go about their business, but there it is. First, I will focus on the role of Dutch Parliament in safeguarding the quality of legislation. Dutch Parliament consists of two chambers. From a standpoint of legislative procedure, the Dutch Parliament may be compared to that of Westminster, the second chamber being the equivalent of the House of Commons, the first chamber being the equivalent of the House of Lords. Lots and lots of differences, of course, but again, no time, so you get the picture. As you may have guessed from the comparison, the second chamber is the most political of the two chambers and offers little in the way of safeguarding legislative quality. The first chamber is generally expected to take a less political stance on the bill than the second chamber, and instead focus on a bill's constitutional aspects, such as its consequences for the enjoyment of fundamental rights. Indeed, the first chamber has been known also in recent years to reject a bill on purely constitutional grounds. But on the whole, because the first chamber remains a political body, it can't be expected to reject bills on purely legislative quality grounds, unless they are very much below standards. So in a nutshell, not much is to be expected of the Dutch Parliament in safeguarding the quality of legislation. This probably comes as no surprise, but let me add one thing that has always fascinated me. Ask a member of the American Congress what he or she does for a living, and the answer will be, I'm a legislator. They speak of members of the English Parliament as lawmakers. Ask a Dutch member of Parliament, especially our second chamber, and the answer will be, my job is to check if the government does its job. That's a fundamentally different perspective. A few remarks on what other mechanisms are in place in the Dutch system to safeguard the quality of legislation. Let me name a few. First, the several drafting manuals and checklists which have, under the supervision of the Ministry of Justice, been developed to ensure the quality of the drafts by other ministerial departments. Second, the Academy for Legislation. For inexperienced as well as experienced drafter, the Academy for Legislation offers training programs. Third, the check on drafts by the Ministry of Justice. Before a draft may be submitted to the Council of Ministers, it has to be reviewed by a special legislative reviewing unit within the Ministry of Justice. If no agreement can be reached between the Ministry of Justice and the ministerial department which drafted the bill, this is noted on the memorandum by which the draft bill is submitted to the Council of Ministers. Fourth, the Internet consultation. For bills which will bring significant change in rights and obligations of citizens or business, or have great impact on society, there's the mandatory procedure of Internet consultation. This means the text of the draft and explanatory note are published on the Internet, and from all corners of society, comments and suggestions may be made. After the Council of Ministers stage, the result of the Internet consultations are made public, as well as the way the comments and suggestions have been dealt with in the draft. Fifth, of course, the role of our Council of State. Traditionally, or Conseil d'État as the French have it, traditionally the Council of State is the most prominent independent keeper of legislative quality. The Council is the highest advisory body to the government. Its advice is mandatory for statute law and royal decrees. The Council checks if the draft bill or royal decree is in accordance with the Constitution and the rule of law, EU law, international law, and standards for legislative technique. Also, the Council of State checks in a detached, apolitical way if the proposed legislative measure is effective and efficient. After a negative advice of the Council of State, the draft bill has again to be tabled for the Council of Ministers. Well, from this view, you may derive that for our system, the parliaments are not very much a safeguard for legislative quality. Are there maybe mechanisms that may be regarded as best practices, which may be recommended to other jurisdictions? Well, as we've seen under the Dutch constitution, only two bodies have the power to reject and/or amend a draft bill, second and the first chamber. All other bodies and mechanisms may be important, may even be mandatory to ask their opinion, but in the end, it's considered by politicians to be just that, an opinion. In my experience, all non-binding institutional mechanisms have, after a relatively brief period of success, a way of becoming just one more obligatory step, a going through the motions. This is the case with the check of draft legislation by the Ministry of Justice, and even the internet consultation procedure, which is relatively new, shows all the signs of having little more than nuisance value for the ministerial departments. So, a pessimistic view? No. All these mechanisms are in itself proof that legislative quality is still considered to be an important part of government policy. Especially the efforts put into the training of legislative drafters and in developing manuals, checklists, and best practices have proven successful. And it may be that many of the checks are non-binding. If the results of a check become part of the public debate, they can be of enormous value to the body of knowledge concerning legislative quality. This is particularly the case with the Council of State. This body, which consists of prominent public officials and legal scholars, has a long-standing experience in assessing legislative quality. Although a negative advice by the Council rarely makes government see the error of its ways, especially if the draft concerns legislation which forms a central part of government policy, the opinion of the Council of State will find its way to the media and will often be part of the debate in Parliament. But in my opinion, the best safeguards for the quality of legislation are education and training of legislative drafters, peer review within the drafting units and ministerial departments, a common understanding of the importance of good legislation, and a sense of noblesse oblige. They are the best safeguards because they are effective, consistent, and sustainable. Without this, all else fails. That's the conclusion of my preliminary remarks. Thank you.
Thank you, Sjoerd, so very much. I think you've made a very, very good point that at the moment, the onus for better legislation seems to be with governments, although I think a lot of colleagues here will make the point that in their jurisdiction, parliaments also play an active role. So thank you very much for it.